So this is my judgment. The claimants commenced this suit by of complaint and other accompanying processes filed on the 2nd of May 2019 and asked for the following reliefs as contained in the statement of fact against the defendant. Number one, a declaration that the claimants, as members of staff of the defendant, are entitled to the payment of their due wages, allowances, and other emoluments by the defendant as are specified in their contract of service with the defendant, as well as the opportunity offered to other members of staff of the defendant to promotion. Number two, a declaration that the defendant's failure to fulfill its contractual obligation to the claimant by paying them their wages, allowances, and other emoluments as due, and deploying them to the respective departments within the defendant's corporation is wrongful, and a deliberate breach of the contract of employment and terms and conditions of service under which the claimants were employed. Number three, an order directing the defendant to immediately deploy the claimants to their respective departments, in line with the claimant's letters of appointment. Number four, an order directing the defendant to, within 45 days of the judgment, immediately place the claimants at the appropriate cadre levels that they would have attained to in the ordinary course of their employment, properly and verifiably coordinated with the position of their peers employed at the same time with them in the defendant corporation. An order directing the defendant to pay within 45 days of the judgment each of the respective claimants in this suit such part of their salaries / wages, allowances, emoluments, and benefits as they would have earned as per the terms in their various employment contracts, including but not limited to leave bonus and Christmas bonus, from the first day of April 2007 until judgment is delivered in this case, together with interest at the prevailing banker rate being 21%. The claimants accruing arrears of salaries / allowances from the defendant calculated at their level entry level grade JSS3 include as follows. 2007, the figures are there. 2008 entitlement and bonuses is there. 2009 to 2018 entitlement and bonuses are there. 2019 entitlement and bonuses are there. Grand total as at March 2019, 671,351,751 naira. Number six, an order directing the defendant to pay the claimant an amount of money calculated to represent the arrears of salaries, allowances, and emoluments and benefits the claimant will have received had they the opportunity to be considered for promotion to ranks higher than their commencing grade level JSS3 from 1st of April 2007 up to the time of judgment, coordinated with and comparable to the current rank of their best performing contemporaries in the service of the defendant. Number seven, for the purpose of the relief 6 above, an order directing the defendant to file in court within 30 days of the judgment an affidavit sworn to by an officer of the defendant not below the rank of the director of the corporation, showing in outline form the current salary / allowances / benefits structure of the best performing member of the staff of the first defendant corporation, including the promotion and salaries increment, who commenced work at the first defendant corporation at the same time and rank as the claimants. Number 8, an order for the payment of interest on the judgment sum at the current rate of 21% from the date of judgment, from the date judgment is delivered in this suit to the date the entire judgment sum is fully paid to the claimant. Number 9, an order directing the defendant to pay the claimant the sum of 100 million naira each as general damages for the unquestionable, for the unquantifiable and extreme hardship caused to the claimants following the continued refusal of the defendant to deploy the claimant and pay their salaries and allowances since April 2007. Number 10, order directing the defendant to pay the claimant the sum of 50 million naira each as aggravated damages. Particulars of the damages: A1, A, B, C, D, E. Number 11, an order directing the defendant to pay the sum of 5 million naira as legal cost of filing and prosecution of this action. The defendant action to the claimant should enter the appearance and file his statement of defense on 10th June 2019 by leave of court. Meanwhile, the claimant also filed a reply to the statement of defense on 28th October 2019, which was deemed as properly filed and served via leave of court. Case of the claimants. From the pleadings filed by the claimants and their testimony, the claimants were offered admission as technical trainees in the Technical Training Center of the Defendant Corporation. The Defendant Corporation was established in 1935 for a number of purposes, which include training and development of technical and engaging and engineering manpower. As on the 3rd of March 2003, the claimants were accordingly admitted as trainees/employees under the pensionable service of the defendant on a JSS3 salary grade in the defendant's salary structure and scheme. That is stipulated in the defendant's letter of offer of admission/appointment to the claimants that the first year of the claimant's employment will be a period of probation, and the claimant were to spend a maximum of 4 years in the training center, and upon successful completion of their program, the claimant will be deployed to various departments of the defendant's workforce. The claimant successfully completed the required mandatory training, but notwithstanding this, the defendant reneged on the terms of employment contract by its continuous and deliberate refusal to deploy the claimants and pay their outstanding salaries from April 2007 to date, despite several entreaties, pleas, demands, and representation by the claimants. Case of the defendants. The defendant's case is, however, that the claimants who are former trainees of the defendant were admitted into various departments in the Technical Training Center of the defendant in the year 2003, and that sometimes in April 2006, they were informed of the closure of the school, but they were later recalled after a series of petitions to various governmental bodies and organizations in October 2006, that after the completion of their program in 2007, they are also they are not absorbed as employees of the defendant. Defendant contended that the claimants are not permanent and pensionable employees of the defendant, nor their employment confirmed. It was also the defendant's averment that it complied with the laid down rules and procedures before the claimant disengagement from service, that the claimants were notified of the directive of the Federal Ministry of Transport to close the training school, as well as the termination of the claimant's employment, and that since April 2007, no services were rendered by the claimants to the defendant to warrant their entitlement to salaries, leave bonus, and emoluments. Trial commenced on 28th of June 2021, where the first claimant, CW1, testified by adopting his written statement on oath dated 2nd May 2019, and tendered exhibit KAG1 to KAG17A and B. CW1 was thereafter cross-examined, re-examined, and discharged. Abubakar Haruna, CW2, testified by adopting his written statement on oath dated 2nd May 2019, and tendered exhibit KAG18AF to exhibit KAG23A and B. CW1 was cross-examined and decided that there was no re-examination. The case of the claimant was then closed, and the matter was adjourned for defense. Defendants opened his case by calling Balogun Shafiddin, DW1, who adopted his witness testimony on oath dated 10th June 2019, and tendered exhibit NPA1, A and B, NPA2, NPA3, and NPA4. Following cross-examination and re-examination of DW1, the case of the defendant was closed, and the matter was adjourned for adoption of final written addresses. Defendant's final written address. Defendant's final written address is dated and filed on 1st March 2022, wherein one issue for termination was submitted by the Lana Senior Advocate Tui. Whether from the totality of the evidence adduced at the trial, the claimants are entitled to the relief sought. Lana Senior Counsel for the defendants submitted that the 10th to 19th claimant cannot maintain this action against the defendants, as their course of action is statute barred under the law, having failed to file any action from 2007 to 2019, a period of 12 years. That's in the case for Nigerian Port Authority and Ajobi, while Supreme Court pronounced on the period of limitation of action against Nigerian Port Authority as provided under Section 110 of the Nigerian Port Authority Act, Laws of Federation of Nigeria 1990. Council also started the case of Omokoro and NPA. Latter Council also submitted that the 10th to 19th claimant offer of admission were respectively made on the 30th day of January 2003, and the 10th to 19th claimant were enjoying all the benefits accruing from the offer of admission until sometime in April 2007. That the 10th to 19th claimant failed to institute any action in court from 2007 to 2019, the instant case, which is a period of 12 years from the year they alleged that defendants stopped paying their entitlements under the respective offers of admission. And although the first and second claimants suing for themselves and on behalf of other persons as well instituted an action at the Federal High Court in 2010, claimants were never parties in their personal or representative capacities in the above mentioned suit. Neither did they apply to be joined thereon. It's a submission of a council that, as for the other claimants left in this suit, that is the first to 9 claimants, by the combined effect of the authority of Nigerian Port Authority and Ajobi, and the provision of Section 110 sub 1 of the Port Act of 1959 establishing the defendant, the suit filed in 2010 in suit number at the Federal High Court, which gave rise to this suit, is equally statute barred, having not been filed within the same prescribed time by the Act. Having not been filed within the time prescribed by the Act, the cause of action in this suit indubitably arose in 2007, and the claimants filed the first action in 2010, a period of about 3 years, citing the case of Podo and Gombe State government. Council contended that the claimants' claims are essentially declaratory reliefs and orders for the payment of salaries and allowances to the claimant, and the onus of proving their case is on the basis of probabilities as provided in their case, and not on the weakness of the defense, and that failure to discharge the onus will be fatal to the claimant's case. Council referred to the case of Adoma Nigerian Air Force and another. Learned Council also contended on the issue of termination of the employment that there are specific preconditions which must be fulfilled before the claimants can succeed. The senior advocate submitted that the ingredients must be evidentially proved before the claimants can sustain their claim, that from the complaint and the statement of fact, the evidential required ingredients were not made out. The senior counsel cited the case of Moro, Fofa, and Kwara Tech. Learned Council also argued that at the trial of this case, the CW1 tendered ID cards issued to the claimants bearing the term trainee, quote and unquote, and the certificate and testimonials tendered also showed that the claimants were simply on training and had simply concluded their training with the defendant. It is the further argument of counsel that the claimants were never employees of the defendant, but only trainees who underwent training without being formally employed as staff, that the claimants' terms of employment were regulated by the conditions of service as well as letters of offer of admission into the technical training center / school. Paragraph 5 of the sale letter of offer dated 30th January 2003 and section to the rules and regulations enforced and made from that the engagement or otherwise of any employee or trainee is subject to the rules and regulations in force and made from time to time by the Nigerian Port Authority. The proviso is very clear that the engagement of the claimant is not automatic, rather it was subject to some other rules regulating the way day-to-day running of the defendant. In the instance case, conditions of service do not apply to an employee whose employment has not been confirmed. The senior counsel referred to paragraph 4 of the offer letter so relied upon by the claimant, which states that, and I quote, upon successful completion of the probation period, your admission/appointment may be confirmed on court. And the senior advocate also submitted that subsequent confirmation is not a mandatory obligation on the defendant. That CW1 said under cross-examination that they are not giving confirmation letters as permanent staff. Counsel also submitted that by section 1.07 of the conditions of service, permanent post is defined as, and I quote, a permanent post is a position occupied by an employee on the completion of a probationary period and the confirmation into that of permanent appointment, unquote. While section 1.09 further provides that, and I quote, pensionable appointment is an appointment so designated by the company in accordance with the existing pension rules, unquote. Submission of learned counsel, that is senior advocate that there's nowhere in the condition of service where it was stated that an employee who was not confirmed and whose appointment was determined on the ground that his services were no longer required is entitled to pension, and counsel urged the court to hold that the claimants are not entitled to any damages and emoluments. Then a senior advocate also submitted that the appropriate authority that can approve the termination of the employment of the claimants is the Honorable Minister of Transport, and that by virtue of the document dated 21st June 2006 marked Exhibit NPA1, the defendant had the directive and instruction of the minister to close the technical training school and the phasing out of the training center with the last batch of students graduating in 2007. And this fact was to the knowledge of the claimants. The Learned Counsel referred to the paragraphs 1 and 2 of the letter of recall exhibit NPA1B, that in the instance case, claimant did not approve and show in the pleaded process how the terms of the contract were breached. The Senior Counsel cited the case of LCRI and Mohammed, where the Court of Appeal held that, and I held those, and I quote, where an employee is on probation as a temporary staff by virtue of his terms of employment, which also state that the appointment will be confirmed subject to his being found suitable, the employer sorry, I'm having network issue. So submission of Lana Senior advocate that the claimant's case is not materially supportable as they failed to establish by credible evidence their perceived right to be reinstated and deployed by the defendant, especially since CW1 stated at the trial that he had not rendered any service to the defendant since 2007, although he was living rent-free in the quarters of the defendant in flagrant violation of section 8.07 of the conditions of service. Counsel submitted that from the totality of the evidence adduced at the trial, the claimant have failed to prove their entitlements to the declaratory and other ancillary reliefs. Submission of Learned Counsel that the claimant are not entitled to any salary, emoluments, allowances, and promotion commencing from 1st April 2007, since their employments were lawfully terminated in accordance with their conditions of service and other extant rules of the defendant. Counsel urged this honorable court to discountenance the claimant's reply to discountenance the claimant's reply to the defendant's statement of defense, saying not being supported by an accompanying statement on oath of a witness for the purpose of cross-examination, as all the evidence adduced therein is incompetent. Claimant's final written address. Claimant's final written address, which is dated and filed on 14th April 2022, was deemed as properly filed and served via leave of court, while the claimant's counsel adopted the sole issue for termination as submitted by the defendant. Counsel argued that from the totality of both the documentary and oral evidence presented before this court, the claimant had entitled to the relief sought. Counsel canvassed his argument according to the following subheads. Number one, facts not in dispute. Number two, employment status of the claimants. Number three, statutory flavor of the claimant's employment. Number four, claimant's entitlement to relief sought. Number five, non-applicability of the statute of limitation. Number one, facts not in dispute. According to counsel, the claimant's trainees were appointed by the defendant in 2003 under a technical trainee contract that for 4 years they received salaries, allowances, bonuses, corporate ID cards, and pension contribution, including a formal employment relationship, that their probation was 1 year, and they successfully completed their training in 2007, receiving certificates. However, since April 2007, the defendant stopped all payments, and despite the training being concluded, never deployed them to permanent roles as promised. It's also argued that the defendant never formally terminated their appointments, while the claimant further participated in company-wide staff verification exercise in 2006 and 2014, which the defendant admits it verified them as trainees. Counsel submitted that in view of the above undisputed fact and following a thoughtful review of the pleadings and oral testimonies of the parties before the court, this undisputed and uncontroverted facts accepted by both parties are deemed established and need not again be further proved based on the principle of law that admitted facts require no further proof, but the same can be relied upon by the court to ground a decision one way or the other. That's in the case of certain section 123 of the Evidence Act, and the cases of Habib Nigerian Bank and Gift Unique Nigeria, Wema Bank and Osilaru, Oyekami and NEPA. It was also submitted by counsel that the above constitutes admission of the fact that the claimants are subsisting employees of the defendant who underwent the defendant's compulsory workforce, that the claimants are thus entitled to regard themselves as employees of the defendant unless and until their various appointments are properly terminated by either party. Employment status of the claimant. Counsel submitted that the issue here is whether there exists a contractual employment relationship between the claimants and the defendant by virtue of the appointment letters, exhibits KAG1, issued to the claimant by the defendant, and whether by the terms of their letters, the defendant is still obligated to the claimant. It's a submission of counsel that it is a settled principle of law that parties are bound by the terms of their agreement or contract freely entered into, and that contract of employment is circumscribed by the terms in the employment letter and workers' handbook if incorporated by reference into the contract of employment. That's in the case of Amadou and Amodi. Counsel also submitted that in construing the terms of a contract, it's the duty of the court to ascertain the intention of parties based on the terms agreed by them and enforce the said terms. In other words, the court cannot make contract for the parties, neither can it vary the terms contained in the contract agreed to by the parties. Rather, the court is bound to give effect to a legitimate contract entered into by the parties, such in the case of Nika Fishing Company and Lavina Corporation. The counsel maintained that in this case, the terms of contract between the claimant and the defendant are well contained in Exhibit 1, which is the letter of offer of admission/appointment, and Exhibit 2, which is the defendant handbook titled Conditions of Service, as revised on the 1st of January 1994, as well as the provisions of the Nigerian Port Authority Act, which is incorporated by reference in Exhibit 1. Counsel also maintained that the claimant's employment relationship with the defendant is governed by the above three documents: the letters of offer of admission issued to the claimants, conditions of service applicable to the claimant's employment, and the NPA Act. And the parties are bound by the terms contained there, that this position is not refuted by the defendant. Counsel submitted that oral evidence cannot be submitted to controvert the content of this document, citing the Supreme Court case of Lewis and Uba. Citing the Supreme Court cases of Lewis and Uba and Dalek Nigeria Limited and Umpade, Council contended that by virtue of the content of the aforementioned documents, particularly Exhibit 1, the claimants were employed as technical trainees in the defendant's pensionable service on the 30th of January 2013 and 3 on a salary grade JSS 3 in the defendant's salary structure. It is a further contention of counsel that on the basis of this appointment letters, the claimant became employees of the defendant on entry job description / rank level, quote and unquote, technical trainees. This is portrayed by the fact that the claimants were all issued staff identity cards by the defendant, evidenced by Exhibit 6, where the word quote and unquote staff is boldly imprinted on the card. That the name of the holder of the card is also imprinted on the card, followed by their rank, which was indicated as trainees. That it also contains claimants' personnel numbers, which is unique to each staff. That the claimants were also, on the basis of this employment, paid monthly salaries and leave allowances. More so, the claimants opened pension account with pension administrators. It's the submission of a counsel that, contrary to the argument of the defendant, it is clear from the appointment letters and actions of parties, including the issuance of sub-identity card, that the claimants were not interns or students, but employees of the defendant who were sent for technical training, which is akin to professional training / education, which many organizations or businesses still do for their staff. It is clear from Exhibit 1 that the purpose of the defendant's training of the claimant is to enable the claimants acquire the required skills and knowledge that will enable them render technical and professional services to the defendant corporation at the required standards. It was submitted that a contract is said to be consummated where there is offer, acceptance, and consideration, such in the case of Royal Excellence Assurance Limited and Onigogi. And the case of SBN and Oponibu, counsel stated that in the instance case, the defendant offer each of the claimants admission / appointment via the letter dated 30th of January 2003, which is stipulated in clear terms and conditions, and this were duly accepted and performed by the claimant. Counsel submitted that the claimants having performed their own part of the contract of undergoing and successfully completing the 4-year train, the 4 years of training, the defendant is bound by the set terms of the contract to deploy the claimants to respective areas or departments of its operations. That if for any reason the defendant did not need the service of the claimants anymore, there are well-established procedures that should be followed to terminate the employment of the claimant. But the defendant has not done so. The employment of the claimant is therefore not called to question, and the claimant are still in the employment of the defendant. The defendant cannot therefore unilaterally and arbitrarily act in contravention of the well-established procedures. Counsel posted that the defendant is bound by the terms of the employment contract, Exhibit A and B, Exhibit A and 2, made with the claimant. Counsel submitted that the defendants claim that the claimants were disengaged from their employment at some point during their employment. Well, counsel submitted that the defendants claim that the claimants were disengaged from their employment at some point during their employment was not established by any material evidence, whether documentary or oral testimony. Counsel also submitted that the defendant never tendered any evidence to show when or how the purported termination of the claimants was made. Submission of counsel that the oral evidence given by the defendant's witnesses to the effect that the claimants were notified of the termination of their appointment without providing any proof of such notification is clearly ineffective for the purpose of vitiating the contract of employment entered into by both parties. Counsel urged the court to hold that paragraphs 17, 18, 20, 47, and 48 of the claimant witness statement on oath have not been controverted. Council reiterated that the claimant's appointments have not in any way been terminated and are still subsisting, and that the defendant is bound to fulfill their part of the terms of the agreement. Then number 3, the question of confirmation of claimant's appointment. Claimants argued that the defendant's failure to terminate the claimant's appointment after their 1-year probationary period in 2004 implies automatic confirmation that their continued employment and training for 4 years without any issue support this. They submitted that there's no evidence to the contrary, that there's no record of any performance issues, queries, or disciplinary actions against any claimant during their entire 4-year training, suggesting their service was satisfactory. Claimants maintain that Exhibit 4 officially attests to satisfactory conduct of each claimant, that probation is a trial period where an employee must prove capability before being considered permanent. That's in the case of WAYO and JSC Benue State, that if an employer fails to either confirm or terminate an employee after the probationary period expires and continues to employ and pay them, the law will deem the appointment confirmed. The employer is stopped from treating the employee as still on probation. That's in the case of Raji and UAE, Council of Federal Polytechnic Ede and Olo Kore. Number 5, statutory flavor of the claimant's employment. It is a submission of a council that the employment of the claimants enjoys statutory flavor, and any supposed termination as alleged by the defendant ought to strictly follow the laid down procedures. It is the law that where a contract of service is governed by the provisions of a statute, while the conditions of service are contained in regulations derived from statutory provisions, any person holding that office or in that employment enjoys a special status over and above the ordinary master and servant relationship. They accordingly enjoy statutory flavor. Such in the case of Osisanya and Afribank, Controller General of Customs, and Gusau. Council stated that the claimant's employment is governed by the Nigerian Port Authority Act, specifically Section 8P, which empowers the NPA to train employees, which it did for the claimant, and Section 11, which governs the appointment and condition of service for NPA employees. And by Section 11, sub 2 of the NPA Act, the defendant requires the approval of Honorable Minister for any regulations or actions relating to employees' conditions of service, including termination. That even if a termination occurred, it was irregular, wrongful, and a nullity because the mandatory statutory procedure, ministerial approval in bracket, was not followed. It was also contended that even if approval was granted, it would only authorize the defendant to act, but would not alter the fundamental statutory nature of the employment contract, which remain protected. The claimant's entitlement to claims. The submission of a counsel that, going by the evidence before the court, establishing that the claimants are subsisting staff of the defendant, as well as considering the fact that there exists no controversy as to the amount being earned by the claimant as monthly salaries, allowances, and benefits, as well as no controversy as to the period of the outstanding salaries of arrears, allowances, and benefits. The claimants are entitled to all their unpaid salaries, benefits, allowances, and bonuses, calculated from when their salaries were wrongfully and unlawfully stopped in April 2007 until judgment is delivered. Council also submitted that the claimants are entitled to be deployed immediately. Furthermore, the submission of a council that the claimants are entitled to all the rights and benefits that could have accrued to them in the course of their employment if they had been deployed by the defendant in April 2007 according to the terms of their contract. These rights and benefits include their rights to promotion and their entitlement to increased salaries. There's no way they could have, within all these years, remained on the same grade level or salary scale. Council cited the case of Balogun and the University of Abuja, Al-Hassan, and Abu Zaria, Olanian, and University of Lagos. Dauda and Lagos Building Investment Company Limited. On the issue of status bar, council submitted that the Port Act relied upon by the defendant is no longer part of our laws in Nigeria, that the act was repealed by Section 3 of the revised edition Laws of Federation of Nigeria 2007, which provides that inter alia that revised edition Laws of the Federation, which is the enabling act of the Fourth Act Laws of Federation of Nigeria, is repealed. That following the repeal of the Fourth Act Laws of Federation of Nigeria, the instant enabling law for the Nigerian Port Authority, the Nigerian Port Authority 2007. More so, the provisions of Section 110 sub 1 of Ports Act, as referred to by the defendant, is not retained or reproduced as a provision governing legal proceedings under Section 92 of the Nigerian Port Authority Act 2007. The Learned Council also submitted that the import of the repeal of the Port Act is that it ceased to exist and it no longer has the force of law, and therefore the court cannot rely on its provisions to us itself or jurisdiction to entertain this suit. That's in the case of the CAFO and Ezelu. Submission of a council that, assuming the said Section 110 sub 1 of the Port Act exists in our laws, the claimant suit as constituted before this court is not a statute bad. Council submitted that the latter part of Section 110 makes continuing injury an exception to the application of the limitation clause by the Act when such act, neglect, or default complained of is continuous in nature. Time will not run until 12 months after it ceases. The submission of a council that, based on the claimant's pleadings, it is abundantly clear that the legal wrong complained of by the claimant is of a continuous nature and is not related to the effect of the injury, but rather to the legal wrong itself, which persists up till now. That the claimant did not stop at pleading continuation of wrong, but also went on to present evidence in proof of same as required by law. Such in the case of Abdurrahman and NNPC, Mobile Producing Nigeria Limited, and Davidson. Defendants apply on points of law. The defendants filed its reply on points of law on 24th May 2022, where it argued that this action does not fall into the category of a continuous injury. That the continuous of injury or damage means continuous of a legal injury, and not merely continuous of the injuries of the injurious effects of a legal injury. Counsel cited the case of Obiafuna and Okoya, Kuhudo and Aine. So, having carefully perused the pleadings of the parties and the evidence presented, as well as the submission of learned counsel for the parties, I have decided to focus on two issues for determination as follows. Number one, whether the claimant's action is statute barred. Number two, whether the claimants have proved their claims to be entitled to the reliefs sought. In determining issue one, this court is tasked to consider whether it has jurisdiction to entertain this suit, following the defendant's averment at paragraph 43 of the statement of defense that the case of the 10th to 19th claimant is statute barred. The defendant, again, in his final written address, contended that both the case of the 1st to 9th claimant, 9th, and that of the 10th to 19th claimant is statute barred, citing Section 110 of the Nigerian Port Authority Act, Laws of Federation of Nigeria 1990, which prescribes a 12-month limitation period for action to be instituted against the defendant. However, the claimants argued that the defendant is relying on an inapplicable law to challenge the court's jurisdiction. It is settled law that a court can only assume jurisdiction if the subject matter is within its jurisdiction. The case has been instituted by due process of law, and any condition precedent to the exercise of its jurisdiction has been fulfilled. See the case of Madukulan in Kemdili. As a general rule, once an action is caught up by a limitation law, it cannot be sustained, and the court is divested of the jurisdiction to entertain it. It is a position of the law that there is a time limit for instituting civil actions, and any action caught by the statute of limitation is dead for all ages. Thus, while a statute of limitation prescribes a period within which an action should be brought, legal proceedings cannot be properly or validly instituted after the expiration of the prescribed period. See the case of Ogunko and Shelley, Ogun State Government and Alami. Section 110, sub 1 of the Fourth Act states thus, and I quote, when any suit is commenced against the authority or any servant of the authority for any act done in persons or execution or intended execution of any act or law, of any public duties or authority, or respect of any alleged neglect or default in the execution of such act, law, duty, or authority, such suit shall not lie or be instituted in any court unless it is commenced within 12 months next after the act, neglect, or default complained of, or in the case of a continuance of injury or damage within 12 months next after ceasing thereof, unquote. I have looked at the Fourth Act, Laws of Federation of Nigeria 1990, and the Nigerian Port Authority Act 2004. I observed that the Fourth Act is repealed by Section 125 of the Nigerian Port Authority Act 2004, and that suggests that the Fourth Act cited by the defendant is no longer part of our law. The current law governing the Nigerian Port Authority is now the Nigerian Port Authority Act, Cap 116 LFN 2004, and Section 110 of the old law the defendant relies on to all the cause resolution was not reproduced in the current Nigerian Port Authority Act, specifically under Section 92, which deals with legal proceedings. Suffice it to say that all the cases cited by learned counsel for the defendant to support his argument in this respect are inapplicable to, as they were decided under the repealed law. Since the Fourth Act has been repealed, it has ceased to exist and has no force of law. Therefore, the court cannot use a provision from a defunct law to declare that it has no jurisdiction to hear the case. In the light of the above, therefore, I hold that Section 110 of the Fourth Act cited by the defendant is inapplicable in this case, as argued by the learned counsel for the claimant. Consequently, the defendant's objection has no merit and is hereby dismissed. I therefore simply hold that this court has the jurisdiction to entertain this suit, entitling the claimant to be heard on merit. Turning to issue number 2, the crux of this case lies in determining the status of the claimant's employment, payment of their entitlements, and the defendant's refusal to deploy the claimants to their respective department. But the defendant's contention is that Exhibit 2, which is the condition of service of the defendant, did not apply to an employee whose employment has not been confirmed, and that the defendant reserved the right to terminate the appointment of the claimant. The law is clear that in civil cases, the burden of proof lies with the claimant to prove their assertions on the balance of probability. This principle is supported by Section 131 and 132 of the Evidence Act and the case of Mrs. Betty Darego and AG Leventis, Nigeria Limited, Alaji Kabiru and another, and John Joseph and another, Adigije and Onwogu, and Chibuko and Chibuko. The above principle of law means that the claimants must provide sufficient evidence to prove their case on the balance of probability. The claimants in a bid to satisfy the above requirement of the law have heavily relied on exhibits KAG 1, 2, 3, KAG 4, KAG 5A to K, KAG 6, 6A to I, KAG 7, 8, and 9, among others, to support their claim. Exhibit KAG 1A to J are copies of the claimant's appointment letters. Exhibit 2 is the defendant's condition of service. Exhibit 3 and 4 are claimant certificate and testimonials of completion of training. Exhibit 5 are verification forms. Exhibit 6 are staff identity card of the claimant. Exhibit 7 are monthly pay slips. Exhibit 8 are vacation leave. And Exhibit 9 are copies of the account with pension managers. In law, when parties, when parties voluntarily enter into a written agreement, they are legally obligated to uphold its terms. Any dispute arising from the relationship must be resolved based on the agreed term, and the courts cannot deviate from what the parties originally intended. The Supreme Court, in the case of Ahmed and CBN, affirmed that parties must adhere to their contractual terms, and courts cannot introduce extraneous provisions unless fraud, duress, or misrepresentation is proven. Additionally, contractual terms are treated with a high level of respect, and any disputes must be interpreted strictly based on the written agreement. Courts do not have the authority to modify or rewrite contracts for the parties, as emphasized in the case of Minas Holdings Limited and AMCON. Similarly, a court, when determining a breach of contract, must strictly rely on the explicit language and meaning of the agreement, as stated in the case of Oyamanda and Abdurrahman. The duty of the court in determining the right and obligation of the parties is to ensure compliance with the terms and conditions of the employment. The court, in determining the second issue framed in the instance suit, suit is equally to ensure that the terms stated in the condition of service and the letter of admission/appointment are complied with. See the case of CBN and Asibon. Let me refer to exhibit KAG 1 A to J, which is stated as follows. Offer of admission/appointment as a technical trainee in a technical training center. I am pleased to inform you that as a result of your performance in the just concluded examination/interview of the above named center, you've been offered an admission as a technical trainee in the authority's pensionable service on a commencing salary grade JSS 3 in the authority's salary structure. You'll be expected to spend a maximum of 4 years in the training center. On successful completion, you'll be deployed appropriately. This admission is subject to the following conditions. Number A, submission of letter of acceptance. Number B, certificate of fitness from the authority's medical doctor. Number C, reference letter of conduct from a senior public servant, clergyman, principal of a school, or secretary of a local government. Willingness to accept the trade allocated to you. Your first job admission will be a period of probation and subject to termination by either side on 1 month notice or salary in lieu. Upon successful completion of the probation period, your admission/appointment may be confirmed. The engagement is otherwise subject to rules and regulations in force and made from time to time by the authority. Your training commences on the 3rd of March 2003 at the Technical Training Center, located at Apapa, Lagos, unquote. Looking at Exhibit 1, the claimant's appointment was subject to a 1-year probationary period, at the end of which their employment was to be either confirmed or terminated. However, after the claimants had served for 1 year, the defendant took neither of these actions. Instead, the defendant continued to utilize the claimant's services. Notably, although the claimants were informed of the closure of the training institute in April 2006, they are recalled in October 2006, 3 years after their initial appointment. This naturally raises the question, why would the defendant recall the claimant in 2006 if their appointment had never been confirmed? Even if it's assumed, without conceding, the defendant never confirmed the claimant's appointment prior to 2007, the defendant was obligated to notify them of this fact immediately after the probationary period ended. Yet, the defendant continued to pay the claimant's salaries beyond the 1 year probationary period. The defendant has not provided any evidence to show that the claimants were never informed of an extension of their probationary period. In fact, it appears that no such extension occurred. Responsibility to confirm or terminate the appointment rested solely with the defendant. Having failed to terminate the claimant's appointment, either during or immediately after the probationary period, the defendant cannot now, 3 years later, rely on the argument that their appointment were never confirmed. The defendant's failure to terminate the claimant's employment implies that, under the terms of Exhibit 1, their appointments became confirmed by operation of law once the defendant continued their employment without any indication of unsatisfactory performance. See the case of Obafemi Awolowo University and Onabanjo. In the all-reported case of Adedeji Oladele Julius at Lagos State Universal Basic Education Board, Judgment delivered on 18 May 2021, it was held on this issue of confirmation that, and I quote, in the case of Iwuju and Federal Commissioner for Establishment, 1985, it was held that where an employee on probation has spent the required probationary period without termination or confirmation of the employee is implied, unquote. Similarly, the Court of Appeal, Eraji and Obafemi Awolowo University, or the JCA, started with approval the dictum of Akpabio JCA, Obafemi Awolowo and Dr. Onabanjo, supra thus. By keeping, and I quote, by keeping him in his employment and continue to pay him for 4 months after a probationary period of 3 years had expired, they would be deemed by operation of law to have confirmed his appointment. And the doctrine of extrapeal by conduct will operate to prevent the appellant from alleging and treat him as if he was still on probation, unquote. I wish to observe that upholding the defendant's argument will permit them to terminate the claimant's employment even after decades of service, simply on the basis that the appointment was never formally confirmed in writing. The law cannot reasonably expect an employee to remain on probation in perpetuity. I therefore find that the claimant's appointment were automatically confirmed under Exhibit A, entitling them to corresponding rights and benefits. The defendant's failure to confirm their appointment and continued refusal to do so over several years constitute a clear breach of the employment terms. Accordingly, the court must not permit the defendant to benefit from a wrongdoing it knowingly failed to remedy. The defendant contended that only the Honorable Minister of Transport had the authority to determine the termination of the claimant's employment. It further claimed to have acted on the minister's directive and instruction to close the technical training center with the final batch of students graduating in 2007. This position appeared to offer the defendant a convenient means of terminating the claimant's employment under any pretext in an attempt to avoid liability for his wrongful conduct in the absence of any valid ground for dismissal, and operating under the belief that it could determine the claimant's fate at will. The defendant proceeded to terminate their employment on that basis. Several factors show that the defendant treated the claimants as employees through various actions. It is evident, as presented by the claimants, that the defendant issued them staff identity cards, paid their monthly salaries and allowances, and contributed to pension scheme accounts opened in their names. Furthermore, the defendant provided them with certificates and testimonials acknowledging their satisfactory performance. The claimant's inclusion in the defendant's staff verification exercise in 2006 and 2014 further support this. These actions collectively indicate that the defendant accepted the claimants as full staff members by conduct. However, the defendant alleged that the claimants are trainees and they were lawfully terminated by the closure of the training institute. It is the law that in the interpretation of statutes or documents which restrict the student's right, any doubt, gap, duplicity, or ambiguity as to the meaning of the words used in the enactment should be resolved in favor of the person who would be liable to the penalty or a deprivation of his right. See the case of Nigerian Navy and Lambert, Onwonsu, and Imo State Environmental Sanitation Authority. I need to point out that even though the claimants were offered appointment as technical trainees by virtue of Exhibit 1, and the institute closed in 2006, but the defendant had recalled them and continued to pay the claimant their salaries and condoned the purported termination up to the time of their completion of the training, which was acknowledged by the defendant issuance sorry, there was a network issue. So, see Section 169 of the Evidence Act 2011, which provides thus, and I quote, When a person, either by virtue of an existing court judgment, deed, or agreement, or by his declaration, act, or omission, intentionally caused or permit another to believe a thing to be true and to act upon such belief, neither he nor his representative in interest shall be allowed in any proceedings between himself and such person or such person's representative in interest to deny the truth of that thing on court. See the case of Mohammed and Jama'ari Emir Council, Irombo, Ironbar, and Federal Mortgage Finance Limited. And again, let's hear what DW1 said under cross-examination. And I quote, by virtue of Exhibit 1, the claimants were offered admission/appointment as technical trainees at the Technical Training Center of the defendant. The management of the defendant issued the claimants Exhibit 1. There was a letter issued to the defendant closing the school. The letter of closure of the school, it's the same thing with the termination letter. After the close of the school, the defendant issued recall letters to all the claimants. There's nothing contained in the recall letter that the claimants were terminated. The period the school was closed was regarded as leave period of pay. Apart from the letter of closure of the training school, there's no document terminating the claimant's offer. There's no document removing the claimant from the defendant's pensionable service on grade JSS 3 in his salary structure because they are not deployed. Yes, the claimants were issued ID cards as technical trainees. Yes, the claimant's pictures are attached to the ID cards. The word staff, quote and unquote, is written on Exhibit 6. The word rank is also written on Exhibit 6, but as technical trainees, unquote. Staff personnel number is also written on Exhibit 6. It is the defendant's duty to deploy the claimant after completion of their training. The claimant spent 4 years for the training, and they completed the training. He went further to say the claimant were issued testimonials and certificates on court. It can be observed that the defendant's decision to place the claimants on his pensionable payroll at grade JSS 3, their formal designation as staff members in Exhibit 6, and the assignment of individual staff personnel numbers to them are further evidence of employment relationship with the defendant. In the case of B. Stabilini Company and Obasa, the Court of Appeal held that contract need not necessarily be a writing. At the corner of the parties, they also create contractual obligations. A contract may be expressed or implied from the conduct of the parties. Also, in the case of Buhari and Takuma, it was held that where there's no written document evidencing contractual relations between the parties, and there's no third party to prove the contractual relationship, the court will fall back on circumstances surrounding the relationship between the parties as narrated by both of them to determine whether there was such a contract. In the case of Nigerian Airways and Bajumo, the Court of Appeal held that where one party employs another, appoints him to various positions in his establishment, pays him salaries and allowances, these acts constitute sufficient facts from which a contract of employment can be inferred, given that the claimants have presented a well-established case demonstrating they are, for all intents and purposes, employees of the defendant, and in light of the defendant's failure to provide a credible or reasonable defense, I find their assertion that the claimants were terminated merely as trainees to be unsubstantiated and without merit, taking cognizance of the fact that the defendant is a product of statute established under Section 1 of the Nigerian Port Authority Act 2004, as correctly argued by the claimant's counsel. I must consider whether the claimant's employment is clothed with statutory flavor. The legal position as established in CBN and Agnes Igulu is that an employment is imbued with statutory flavor when it is safeguarded by statute or by regulations that govern the procedures for employment and discipline. Section 11 sub 2 of the Nigerian Port Authority Act says, and I quote, the authority may, with the approval of the minister, make regulations generally relating to the conditions of service of the employees of the authority, unquote. It can be seen that by virtue of Exhibit 1, claimant's appointment letters, which made reference to Exhibit 2, defendant's condition of service, as well as the Nigerian Port Authority Act that acts, the defendant is the creation of a statute and its operations are regulated by the Act that establishes it. It is therefore beyond doubt that the employment of the claimant is one that is structurally flammable, so fine and hold. And when an employment contract is regulated by statute, or when conditions of service are derived from the statutory regulations, as in the instance case, the employee holds a legal status beyond that of a typical master-servant relationship, as established in the case of Ms. Bao, Adeni, and Ejibu local government. The only valid way to terminate claimant's employment is strictly following the statutory procedure. Any termination that derives from the prescribed legal process is null, void, and ineffective. For the claimant's relief, 4, 5, 6, and 7, it's well established through long line of cases that promotion is a privilege, not a right. For an employee to qualify for promotion, they must demonstrate that they have met all the prerequisite conditions outlined in the contract of employment. The Supreme Court has clearly held that moving from one rank or position to another within an organization is a privilege that must be earned, not a guaranteed entitlement. An employer cannot be compelled to promote an employee regardless of how highly the employee regards their own performance. This principle is supported by the case of Ngoe and Fan, and Benga and Benue Judicial Service Commission. Furthermore, because the criteria for promotion differs across organizations, the court will not intervene in matters of internal administrative policy as affirmed in the case of MAMA and ICPC. Accordingly, these reliefs cannot succeed. From all that has been said, I'm satisfied that the claimants have proved their case and entitled to some of the reliefs sought. For the avoidance of doubt, it is hereby declared and ordered as follows. Number 1, a declaration that the claimants are members of staff of the defendant and entitled to the payment of their due wages, allowances, and other emoluments by the defendant as specified in their contract of service with the defendant. Number 2, a declaration that the defendant's failure to fulfill its contractual obligations to the claimants by paying their wages, allowances, and other emoluments as due and deploying them to the respective departments within the defendant corporation is unlawful and a deliberate breach of the contract of employment and terms and conditions of service under which the claimants were employed. Number 3, another direction the defendant immediately deploy the claimants to the respective departments in line with the claimants' letters of appointment and place them at the appropriate cadre levels. Number 5, another direction the defendant to immediately pay each of the respective claimants in this suit their salaries / wages, allowances, emoluments, and benefits as they would have earned as per the terms in their various employment contracts, including but not limited to leave bonus and Christmas bonus, at the rate of 38,132 naira monthly from the 1st of April 2007 to date of judgment. The claimant shall also be paid the yearly bonus of 38,132 naira as well as the end of year Christmas bonus of 38,132 from 2007 to date. 20 million naira general damages is awarded in favor of the claimants against the defendant by virtue of Section 19 of the National Industrial Court Act. 2 million naira cost is also awarded in favor of the claimants against the defendant. The sales sum shall attract 10% for judgment interest until it's fully liquidated. Yes. Yes.
Thank you, my lord. We are most grateful, sir. Thank you so much. Consider doing, sir.
Lanesen, thank you too.
Situation whereby the learned counsel for the claimant will first of all address your lordship upon the pronouncement of the judgment before we react. We are expecting, I'm expecting my learned my learned colleague, Destina Daluma, to first of all address your lordship upon the delivery of this judgment before I react.
Yeah, but still in order, you are the senior counsel now, isn't it?
In view of the observation and the position of your lordship, I want to most sincerely thank your lordship, especially for the industry put into the judgment one, and for your tenacity in conclusively hearing this matter. It's been long time, but there's nothing we can do because we are not unaware of the various commitments of the judgment as delivered by your lordship, but on the for the industry you have actually exhibited in the delivery of the judgment and the contents therein. Whatever is the position of our client who engage us for the purpose of prosecuting this case in terms of defense, where we will take the necessary action based on their own reaction and position. May God continue to increase you in knowledge in all circumstances. Thank you very much, my Lord, and God bless you.
Lanesen, thank you so much. Thank you so much. I'm appreciative of that. Thank you. It's like
yes, sir. Yes, sir.
It's like we have lost Destina and Chumweze.
Yes, sir.
We are here, my Lord.
Okay, we are here.
My Lord. And my Lord, I earlier said we are most grateful, sir, for the well-considered judgment. I can't even express my emotion at the moment.
Is that Destina or Chimweze?
Destina, sir. It's Destina, sir. Chinelo is meant to lead me, but I guess she has network issues.
Yes,
I guess she has network issues. Thank you so much, my Lord. We are most grateful, and I certainly do not know how to what my emotion is right now, but we are most grateful because it's like putting life to as many who have supposedly they are working, but some of them are sincerely, my Lord, working costs. But I'm so very grateful, sir. And we are saying thank you so much, sir, for the well-considered judgment. Thank you. The Lord will continue to bless the work of your hands, sir. Thank you, sir.
Thank you, Chu. I'm grateful. It is my opinion. It's subject to appeal. You know, it's not final, isn't it, Lana SAN? It's not final, just my opinion that I've expressed in the judgment. So it's subject to, you know, appeal to the court of appeal. So I'm grateful and thank everybody. I thank Lana SAN. Lana SAN, I've learned a lot from you. Lana SAN. Lana SAN. Oh, okay, you are muted.
Thank you, my Lord.
Thank you, Lana SAN.
My Lord, when are we likely to get the judgment as delivered by your lordship, sir?
Yeah, we'll send it. We'll send it very, very soon. God willing.
Okay. Okay, yes, sir.
We'll send it.
I wish you best.
Yes, my Lord. I thank you so much. I've learned from you. I've learned so many things from you. I wish you well, and I'm looking forward to meeting you again. Yes.
Okay, sir.
Thank you.
Thank you very much, my Lord.
Thank you so much.
Thank you, sir.
Thank you so much.
Daluma?
Yes, sir.
Hello, Daluma?
Yes, sir.
I wish you well. We meet very soon again by the grace of God. This is not going to be our last meeting.
That's what I'm saying.
And I wish you best of future endeavors.
Thank you very much, sir. Thank you very much.
It's all right.
Yes, sir.
Thank you so much.
Yes,
thank you, sir.
Yes,
so I wish you well. I wish everybody good afternoon. And
thank you, sir.
In the absence of any other thing, permit me to leave.
As it pleases. We are most grateful, sir.
Thank you. Bye-bye. Thank you.
Goodbye, sir.
Thank you. Bye-bye. Good afternoon. Thank you.
Uje, congratulations to every one of you. So when we leave now, we'll speak with you people. Thank you so very much. God bless you. God bless you.
God bless you, man. We appreciate the Lord is our strength.
Yeah,
Thank you.
congratulations. Yeah,
Congrats.
bye. Kuku, I can see you. Congratulations.
Yes, we're very most grateful, and God bless you all. More strength and greater heights, man. Thank you so much.
Amen. Amen. Thank you. We'll call shortly. Thank you.
Okay, we'll communicate. Thank you, man.
Yeah, bye.
And, and to every other training, step up, and God bless you all, and thank you and congratulations.
Yeah, thank you.